Welcome to the Deep Dive. Today we are focusing on a regulatory ultimatum that has just landed squarely in the middle of the AI sector.
It really has.
The question is pretty simple. Will AI policy be dictated by Washington, D.C., or by this chaotic patchwork of states like California and Texas?
And it looks like we're about to get an answer.
We're deep diving into the administration's incredibly aggressive move to establish one uniform federal AI policy framework. And, this isn't about drafting new legislation.
Not at all. This is a declaration of war.
A declaration of war on state rulemaking, delivered via an executive order signed on December 11th, 2025. It's aiming to just preempt this rising chaotic tide of state-level AI regulations.
The ones developers have been saying are just strangling innovation.
Exactly. Okay, so let's just unpack this with a snapshot of the results. What's the mission statement here?
Well, the policy is pretty explicit. The administration says the United States must sustain and enhance its global AI dominance.
And the way to do that is a single, minimally burdensome national policy framework. Basically, they're trading 50 state rule books for one federal one.
And the mechanism for getting there is surprisingly aggressive.
It is. The executive order signals a clear legal confrontation with states. It's using this multi-pronged approach involving litigation, federal funding leverage,
and regulatory rulemaking, all designed specifically to dismantle what they keep calling the patchwork.
Right. So for experienced investors listening, you have to see this as a major de-risking event. This regulatory friction is being pulled out of the system.
Which means, slashing compliance costs and legal complexity for the big AI developers.
It paves a smoother, faster road for deployment across the whole country.
What's really fascinating here is how clearly this signal represents a major pivot in federal philosophy.
How so?
If we connect this to the bigger picture, you see a really distinct shift away from AI safety. All those cautious governance concerns that dominated policy discussions just a couple of years ago.
All that seems to be gone.
It's gone. Now, the emphasis is entirely on security, on innovation, and this really aggressive build, baby, build approach. It's all aimed at maximizing our domestic competitive advantage.
And this didn't come out of nowhere. You could kind of see it coming.
It was definitely foreshadowed.
Yeah.
EO 44179, back in January 2025, that was the precursor. It was all about finding and removing regulatory barriers. But the sheer aggression of this new order is striking.
And the administration kind of had to act, right? The state-level chaos was becoming unmanageable.
Oh, absolutely. The need for federal action wasn't just hypothetical. It was driven by pure regulatory volume.
What are we talking about, numbers-wise?
We're talking over 1,000. Over 1,000 AI-related bills introduced in 48 states and Puerto Rico, just in the 2025 legislative session alone.
Wow.
Yeah. That proliferation created this unsustainable patchwork that the federal government now claims makes this heavy-handed preemption necessary.
So what are the specific conflict points they're citing?
They've laid out 3, and they focus really intensely on the friction for commercial AI developers. First, and this is the simple one, the complexity of 50 different regimes is a crippling compliance burden.
Especially for startups.
For startups, it's a nightmare. That's just straightforward economics.
But the second point is where the political and legal friction really starts to flare up.
It is.
They're arguing some state laws cross a line, that they're forcing AI models to embed what the administration is calling ideological bias.
Exactly. This is the crucial conflict. They singled out Colorado's algorithmic discrimination law, SB 24205.
And the argument is what?
The argument is that a law like that could force models to produce what are essentially false results, just to avoid a differential impact on protected groups.
Okay, can you give me a practical example? How does a law mandate a false result?
Sure. Think of a hiring algorithm or a lending model. If the AI, based on statistically valid data, accurately predicts that certain applicants carry a higher risk, but that prediction disproportionately affects a protected group, the state law, because it's pursuing purely equitable outcomes, might compel the developer to manually alter the model's output.
So if the model says X, but X leads to a disparate impact, the law might force the output to be Y.
Precisely. And the federal government's argument is that this mandates deception in the name of social goals. And that undermines the whole point, the utility and truthfulness of the AI itself.
And the third conflict point.
That's the constitutional one, the argument that many of these state laws are just impermissibly regulating interstate commerce. stepping outside their constitutional bounds.
Classic preemption fight.
The classic fight.
So that brings us to the immediate targets. If you're an investor, you need to know which state laws are squarely in the federal crosshairs.
We have several key ones. First up is California's Transparency in Frontier Artificial Intelligence Act, or TFAIA.
Okay.
This one applies specifically to the massive frontier models. We're talking ones trained with over 10 to the 26 FLOPs. It imposes these huge catastrophic risk mitigation requirements.
How catastrophic are we talking?
It's defined really severely. Foreseeable risks of injury to more than 50 people or over $1 billion in property damage. It's a massive compliance barrier for the largest AI firms. The feds want it gone.
And what about Texas, the other big tech hub?
Texas is also a target with its Responsible AI Governance Act, or REAGA. That regulates developers on things like creating unlawful deepfakes or infringing on federal rights.
A bit less restrictive than California, then?
It is, but it still represents a state-level layer the administration sees as burdensome. And then you also have California's AB 325, the Preventing Algorithmic Price Fixing Act. The new DOJ task force will be looking very closely at all of these for an immediate challenge.
So that sets up the battlefield. Now let's pivot to the mechanics of the attack. How is the administration actually operationalizing this strategy against 50 state capitals?
This is where the genius, or maybe the cynicism, of the executive order really lies. It set up three very potent overlapping mechanisms.
Okay, what's number one?
First, and this is the most important, is the judicial front. Within 30 days, the Attorney General must establish an AI litigation task force.
And its job is?
Its sole responsibility is to challenge conflicting state laws on preemption or unconstitutional interstate commerce grounds. It's an organized, federally funded legal assault.
A legal assault team. What's next?
Second, the Commerce Department. They're playing the regulatory intelligence role. Within 90 days, the Secretary has to publish an evaluation identifying onerous state laws.
And onerous means?
It means laws that demand altering truthful AI outputs or compel, First Amendment violating disclosures, forced speech, basically, like certain disclaimers on model outputs. Once Commerce identifies them, they get referred directly to the DOJ task force for action.
That timeline, 30 and 90 days, that's a huge catalyst. Corporate legal teams are going to just pause everything. But let's talk about the funding lever. This is a massive power play.
It is a massive power play. The administration is connecting high-speed internet funding directly to AI regulatory compliance. The Commerce Department is directed to issue a policy notice about the BEAD program.
Wait, BEAD? That's the Broadband Equity Access and Deployment Program. You're saying they're holding infrastructure money for high-speed internet hostage to dictate AI ethics laws.
That's precisely the mechanism.
That's not regulatory policy. That's just pure political coercion.
It is. States with onerous AI laws will be deemed ineligible for the remaining BEAD non-deployment funds. And it's not just BEAD. Agencies across the government have to review their discretionary grant programs.
So education grants, infrastructure.
All of it. To condition that funding on states either not enacting or agreeing not to enforce any of these conflicting AI laws, they are using the full weight of the federal purse to force compliance.
And the preemption doesn't stop there. We're seeing existing federal agencies being, weaponized as well, right?
Correct. Two key regulatory pathways are being opened up to override state mandates. First, the FCC is directed to start a proceeding on a federal reporting and disclosure standard for AI models.
Which is explicitly designed to preempt conflicting state laws.
Exactly. The goal is to set one national disclosure bar that just nullifies 50 different state-specific requirements.
And the other one?
Simultaneously, the Federal Trade Commission is directed to issue a policy statement. This will clarify how the FTC Act, specifically the part about unfair and deceptive acts, preempts state laws that mandate altering truthful AI outputs.
So they're using federal consumer protection law to strike down those false results we talked about.
Right. They're arguing that forcing a model to lie is inherently deceptive to the consumer.
So you've got the legal attack, the funding leverage, and regulatory overrides, a comprehensive strategy. What's the financial upside for big tech if this actually works? I saw the CCIA floated some staggering numbers.
They did. They're estimating federal preemption could yield a $600 billion fiscal windfall through 2035.
$600 billion.
It sounds huge, but the breakdown is key. The bulk of that, $561 billion, is projected to come from higher federal tax receipts, which, flows from increased GDP.
But how does reducing friction lead to $561 billion in tax revenue? Explain that connection.
It's the productivity argument, just writ large. A single national standard lets models scale faster, deploy nationally, without all this costly retooling.
Got it.
This acceleration of deployment leads to massive productivity gains across the whole economy: healthcare, manufacturing, finance. That drives GDP growth, and that leads to a higher corporate and income tax revenue.
Then a rest.
The remaining $39 billion comes from lower federal procurement costs. The government can just buy standardized AI solutions instead of bespoke state-compliant versions.
That's the financial case, but the pushback is going to be fierce. This is a direct attack on federalism. What's the risk calculus here?
The state leaders are absolutely preparing for this fight. You're already seeing visible figures, the California AG, state senators, high-profile GOP leaders like DeSantis in Florida and Senator Josh Hawley.
They're all signaling legal challenges.
Right. And their arguments are going to be multifaceted. They'll focus on federalism, the 10th Amendment, asserting that power is not delegated to the feds or reserved for the states.
And they'll go after the funding lever.
Crucially, they will challenge the use of the spending clause, arguing that conditioning BEAD grants on AI policy is coercive and totally unrelated to the purpose of the funding. This promises a prolonged period of legal uncertainty.
So investors need to know that this $600 billion windfall is currently locked up in litigation risk.
Absolutely.
Okay, one critical nuance for employers. Even if the federal government successfully preempts the state AI-specific laws, does that eliminate all liability for companies using these models in, say, HR or recruiting?
No. Absolutely not, and this is vital. Even if the state algorithmic bias laws get invalidated, employers remain fully exposed to litigation under the existing federal EEO frameworks.
So Title VII, the ADA, the Age Discrimination in Employment Act.
All of them. The liability just pivots to the discriminatory outcome of an AI-driven decision, regardless of whether a specific state law is on the books. The focus shifts from regulating the input, the algorithm, to regulating the result, the employment decision.
Before we move to trade ideas, we have to revisit the carve-outs. Were there any areas where the feds explicitly said states can still regulate?
Yes, and these are crucial because they inform our trade ideas. The executive order's recommendations explicitly protect 3 areas from preemption.
Okay.
First, child safety protections. Second, and this is the big one, AI, compute, and data center infrastructure, though there's a little exception for permitting reforms.
And third?
Third is state government procurement and use of AI. But that protection of compute infrastructure is so critical. It shows the federal government is prioritizing the deployment of AI over the physical resource management for AI.
And this is where that regulatory friction converts into potential alpha. This executive order is a seismic event that creates predictable winners and losers.
Let's start with a trade idea, derived directly from that compute carve-out. The idea is long AI infrastructure in fragmented states.
Okay, lay out the thesis.
It's straightforward, really, and it's based on the regulatory moat. The EO explicitly protects state regulation of AI compute and data center infrastructure. So states like California and Texas, with their aggressive policy agendas, they're going to keep applying pressure and regulatory overhead on permitting, on resource allocation.
Especially power and water.
Especially power and water for new data center builds.
So if the feds are removing friction for the software, but actively protecting the friction points for the hardware build-out, that creates scarcity.
Precisely. This regulatory pressure creates scarcity, which means higher value capture for the established data center operators who are already in those dense, high demand, but increasingly restrictive environments.
So the actionable bet is?
Go long established data center operators.
Right.
Or utilities with a high energy footprint in states that have these new infrastructure regulations that the federal government cannot touch. You're banking on this regulatory moat driving scarcity value.
That makes a lot of sense. What's the immediate counter risk to that long thesis?
The counter risk is that that little exception, the one for generally applicable permitting reforms, gets interpreted really broadly by the courts. If the feds can force rapid national permitting for things like high voltage transmission lines or water rights, that could undermine the state's ability to create that moat. You could see an oversupply of compute capacity.
Understood. My trade idea is on the short side, focused on the sudden collapse in demand for a certain type of service. I'm proposing we short regulatory arbitration software.
Yeah, interesting.
The thesis is simple. The executive order's stated goal is a single federal standard. If they're successful, that just collapses the entire value proposition of all these regional compliance software platforms and consulting firms.
The ones that specialize in navigating the 50-state patchwork.
Exactly. They exist to manage fragmentation, and that fragmentation is now explicitly targeted for elimination.
And critically, those immediate 90-day triggers, the Commerce Review, the FCC and FTC actions, they introduce way too much uncertainty. Corporate clients aren't going to keep paying for state-by-state compliance solutions.
Right. Why pay a premium for software designed to navigate a system that might be legally invalid in 3 months?
You wouldn't?
Corporate clients will immediately pause those subscriptions. They'll wait for the federal standard to materialize, which creates immediate demand compression. So the bet is to short regional or private equity-backed legal and compliance tech firms whose main revenue driver is multi-state AI readiness. We anticipate that paralysis in legal spending will hit their revenues hard very soon.
A really interesting play on the second-order effects.
This executive order has initiated a massive regulatory shockwave. It's fundamentally transforming the operating environment for AI firms. The true battle for AI dominance is now, it's transitioning from the research lab to the courtroom.
And that will determine whether the speed of innovation, driven by big tech and the feds, or the protection of rights and local control, championed by the states, sets the ultimate pace of deployment.
Remember, the information presented here is based on available public source material and analysis. It's intended for informational and educational purposes only. This is not financial advice.
Please, conduct your own due diligence.
We'll continue to track the 30-day and 90-day deadlines, including the launch of that DOJ task force and the Commerce Department's list of onerous laws. Thank you for joining us on The Deep Dive.